Hey everyone, Harry here to talk about the brief on the merits from the other side, not Trump, but the challengers in the U.S. Supreme Court case that's going to be heard very soon on February 8th. So the basic schedule is that Trump filed his about 10 days ago, and then these guys actually filed a little bit early. It was due no later than January 31st. Trump will then do a reply brief on the 5th of February, and on the 8th, the court will hear it. That is, as we've talked about before, warp speed for the U.S. Supreme Court. Okay, so this is also the date, or the 31st is the date when amicus briefs in support of respondent should come in, or that's their deadline. Many have already come in, but we can expect an additional flurry. Okay, so what do we learn, or what's in the respondent's brief? First, it's totally solid. It's well done. You know, at this point, it's a really interesting and challenging set of issues for the court, because you can really see what the clear answers are on each side, but it's hard to choose between them. So the challengers here, I'll call them the respondents, because they won below, so they're responding to to Trump in the U.S. Supreme Court. Sound all the right themes. They go through arguments that we've talked about, I've written about, but they first basically say Trump's just making largely political arguments. He's threatening U.S. Supreme Court, by saying bedlam will ensue if you affirm Colorado, or if you do, and of course if you take him off the ballot. And he does say that, and I think it is something that will weigh heavy on the U.S. Supreme Court. We've talked about this. I think, even though the Constitution doesn't, as best I can tell, doesn't forbid it, the notion of different patterns in different states, I think, will give the court the heebie-jeebies, for lack of a better legal term. But they make this nice point, do the respondents here, which is they say, it'll be bedlam if he's not on the ballot. But we already saw the bedlam Trump unleashed when he was on the ballot and lost. And Section 3 is designed precisely to avoid giving oath-breaking insurrectionists, a nice little description, like Trump, the power to unleash such mayhem again. And so it's an implicit comparison between the patchwork situation I've talked about, or the blunt remedy of taking him off the ballot on the one hand, and the actual mayhem, the actual insurrection itself, which we're trying to prevent a recurrence of. So in other words, it's not just patchwork situation versus no patchwork situation. It's what's on the other side here, potential bedlam, which the Constitution takes cognizance of in precisely this situation where somebody has sworn an oath to uphold and then has engaged in insurrection. All right. And the engaged in insurrection part, it's all the sort of standard arguments for why it's an insurrection, why it's engaged in it, except there's a very heavy flavor here of something that you would think would normally, and maybe in this case, be influential on the justices, especially the conservative justices, which is, as they stated, states and not the federal political branches that have primary responsibility to decide presidential qualifications at the ballot access stage. And that's just true. And, I analogize again to if he were 34, and it would seem impeccable for a state to make that judgment. In fact, states make exactly those kinds of judgments. I wouldn't say all the time, because not too many, 34-year-olds run for president, but there are disputes about national status or things that would matter. And that's what the state process is there for. So why is it completely different or inapposite just because it's this provision that's more complicated and used less frequently? Doesn't state power as a matter of power, isn't it still the same? So it's not for the court to displace the state power. In a similar, but I'd say it's a bigger stretch, but they make the same point as they sort of need to about the fact finding here. So they go through it, and they do go through the facts, and in fact, it's an interesting aspect of their brief that there's pictures. They take up a lot of space, and you're limited in how much space you can use with really nasty, violent-looking pictures. And but they make the point, and then they say the trial court's factual findings are entitled to substantial deference. But that's a very tricky proposition. Normally, it's true. The Supreme Court certainly can't make its own factual findings, and they don't. And in the very rare case where somebody has to, they would appoint an officer, sort of special monitor, or to go and do a fact-finding process. Ain't going to happen here. So normally it is. I mean, it's true that the court won't have the constitutional authority or wherewithal to overturn the factual findings. So in that sense, they're entitled to substantial deference, but it's a very different question to take the findings, even the reasonable ones that look pretty impressive, of one Colorado state trial judge and impose it on the federal Constitution for the entire country. So in this, encapsulated in this pretty regular pedestrian statement of appellate law, these findings are entitled to substantial deference, is a very tricky little question about state versus federal law, because it's uncontroversial that the court would say, we detect no error of federal law in the fact findings of the Colorado Supreme Court. But what they're really saying they should defer to, what that means is the court should say that these findings, because they have, maybe they're wrong. I don't think they are, but if the legal analysis would be, even if they're wrong, if they're close enough, you defer to them, and that becomes a sort of constitutional fact that triggers the 14th Amendment. But, can an individual judge for the Colorado trial court bind the federal government that way? You can imagine, for example, two reasonable findings of fact by different states that go the other way. One says, there's no engaging in insurrection. And the other says there is. And, to be clear, on the facts, I think it's very clear, and most observers think it's very clear, engaged in insurrection. But just take the mental exercise of thinking that they've gone in different directions, but both are reasonable. Then would the court be? You can't defer to both, at least if deferring means making it a federal constitutional rule and a finding that he engaged. And then the final point that they make, and they make all the normal points we've talked about, but their themes of the bedlam here is Trump's, not what he's suggesting you would create court by ruling against him. The findings are entitled to substantial deference. It's state power that really is paramount in this area. And then finally, they make a fair bit of the last provision of Section 3, which says Congress can cure. If a court bounces Trump and 2/3 of each House of Congress wants to reinstate him, it can. Of course, everyone knows that would never happen, but it would change the onus onto Trump. But what it means is there's some political failsafe at the end of the process. And so to the extent you're concerned with some congruence with the political will in the country, you have that. So solid brief, and it just sets up, as I've said before, really interesting and strong in some ways arguments on both sides, much stronger in terms of Trump's not qualifying for the ballot because he did these things, but still a swirling series of hard questions for the court about how this should be decided. Again, if it were a minor presidential candidate being eliminated from the ballot, Ralph Nader in Pennsylvania that I worked on in 2000, or it were, the cut and dried fact of is somebody 35, it totally would be fine for the states to decide this. So what's the difference here? And how will the court express it? So they've gone to the heart of the issues and served them up for the court. I just want to state one other point. I said that the 31st is the date for also amicus briefs in support of respondents. And we've got a pretty interesting one by American historians to include, by the way, the previous president of Harvard, Drew Faust, who's a historian. I think she was the first woman president of Harvard. And that brief makes a very nice argument that I haven't seen before that suggests that the Trump position that officers in Section 3 doesn't include former presidents is all wet, because Jefferson Davis, it looks to his prosecution for treason, and it comes up again and again in that prosecution, which ultimately is kind of politically smothered. That's a whole long and interesting story in and of itself. But Jefferson Davis himself suggests that he's disqualified under Section 3, and a big historian who really helped frame, not historian, actual, legal scholar at the time who helped write these provisions says the same. So they marshal some very strong contemporary evidence that says, people, just as we say today, are you telling me that provision means Jefferson Davis could have been president? There's a very similar kind of head scratching that goes on in the contemporary period, which I think could be influential for the court and suggests that for sure Jefferson Davis was meant to be covered by Section 3 of the 14th Amendment, and therefore that the argument that officers doesn't include the president himself or herself doesn't fly. Okay, man, so much going on in this case, more to come. And I'm going to actually go to the oral argument and we'll be able to give you all kinds of observations, but this is already one for the ages. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.